This Lordship, my Lord, I beg to mention here in item number 23 that this matter will be listed after 2 weeks, Lordship. 20? Item number 23. That this matter will be listed after 2 weeks, Lordship. After 3 weeks. You're for? I'm for the appellant. Mr. The Blue Marshal Lordship. And counsel for appellant, pray for listing this matter after 3 weeks. The prayer is allowed to list this matter after 3 weeks. Okay. Much obliged.
Please, Your Lordship. Bishop, I beg to mention item number 17, Lordship. Bishop, here I have received the counter filed by the respondent number 1 to 3, Your Lordship. So if I may be granted 3 weeks time to file my reply, Your Lordship.
I have no objections, Lordship. 3 weeks time to file?
Reply to the affidavit
Okay.
filed by respondent number 1 to 3,
Okay,
Your Lordship.
Miss
Please, Lucino, for the moment.
Lucino, learned counsel for the petitioner prays for 3 weeks times to file reply with Mr. Santiago. Learned counsel for the respondent has no objection. Stop. The prayer is allowed. List this matter after 3 weeks.
And also,
With your
Lordship, service report on respondent number 9, Lordship, is still awaited. So,
Here in this case,
yes, Lordship, it's in the
Okay.
orders. Lordship.
the service report in respect of respondent number 9 is still awaited.
So, Lordship, if I may be allowed to take fresh steps to justice service,
And-
Lordship.
So in view of the office note, Ms. Luciano, land counsel for the petitioner prays for allowing her to take fresh steps upon the respondent number 9.
Number 9, Lordship.
The prayer is allowed. Step be taken within a week from today.
Lordship.
Okay.
Through Dusty, Lordship.
Through Dusty.
That's
Okay, through Dusty,
obliged, Lordship.
Deeply obliged. Yeah, please, Your Lordship. Lordship, I beg to mention hearing item number 24, Lordship. Yes. On behalf of my colleague Lucas, Lordship, if this matter can come up next week, Lordship. She's for a state respondent.
No objection, Lordship.
Okay.
Lordship, if
Yes.
it can come up on Monday, Lordship, 29.
Next week. Next week. We'll say next week.
Monday, Lordship, 29, Lordship.
Okay. It's prayed for by the Land Council for the party. List this matter on Monday.
Lordship, there's an interim here.
The interim of the past earlier said continue till then. Okay.
Obliged, Lordship.
Lordship, I have similar prayer for item number 1 and 2, Lordship. On behalf of my colleague Lucas, Lordship. If this matter can come up next week. Next week. What? Next week. Item 1.
Lordship, there is a lot of topsy-turvy in this case. The writ petition was filed seeking a direction from this honorable court, the respondents to consider my appointment on the basis of land ownership. When that matter was pending, another appointment was made. So we were compelled to challenge that appointment also. And ultimately, it came to our knowledge that that appointment was on compassionate ground.
Okay.
Now, since that appointment is on compassionate ground, okay, he may have a case. But then there was another vacancy in the meantime arose. So we applied for that vacancy. We have pointed out to the government that, look, there is a vacancy, so a direction may be issued to consider my case against that vacancy. Taking advantage of that, government has made another appointment in the vacancy which I have pointed out that, look, there is one vacancy. So government has again appointed another person. We have got the appointment order. But then government approval order was not available with us. Therefore, we need to challenge that appointment also. So we need 3 weeks time, and Lordship may find from the records. On the last occasion, this honorable court has passed an order to consider to confine my prayer on the paragraph 3 of clause P, where there is a provision that the cases of the landowners can be considered. and the direction will be issued to the district administration to consider and examine. And if I am found eligible, then my case may be considered. And if I am not found to be a genuine landowner, then my case will be out. Therefore, I need 2 weeks' time to challenge that new appointment so that all the cases may be clubbed together. And then I'm looking for only one vacancy. So the latest appointment I need to challenge. So 2 weeks' time may be given, Lordship. Carmen is asking for 1 week time. I need 2 weeks' time, Lordship, to enable me to challenge the latest appointment order, Lordship. Of course, I have no much grievance against the private respondent.
Otherwise, here this has been listed in admission column. So this otherwise is ready for hearing because I
Yes,
seen that. affidavit-
Lordship, this can be disposed of at the admission stage.
Okay.
Your
So
Lordship,
3 weeks.
there is one thing, filing a new petition wherein I'll not be a party as appear from the submission made
Oh,
by my
okay.
other friend.
Mm.
I'll not be a party.
Right, right.
Now,
You're for the private respondent.
Your Lordship,
Yes.
now this is pending since 2022.
Mm.
Now, if we are to dispose of along with the new petition, now it will take another 1-2 years because they will file a
Affidavit.
petition,
Mm.
they will file notice, notice will be issued, then the government will file counter, then who will be the respondent there, private respondent, he also will file counter,
Right,
That-
that is true.
rejoinder, perhaps reply. So it will take another 1-2 years. Then in the present case, the only question is now, number one, admittedly from the records, the petitioner is not the landowner. Secondly, my appointment to the post is as per the direction of the Honorable High Court on compassionate ground. Thirdly, the 2018 notification, which clause 3,
Yes.
which is relied by the petitioner, is not applicable because he is not the landowner. Number 4, for that land, compensation has been paid.
To the
That is-
petitioner.
Yes.
Hmm.
To the owner of the land, because petitioner is not the owner of the land. He is
Petitioner
claiming,
is among the owner.
yes,
Not
he
the
is
owner.
not even the owner because
Okay.
he is claiming the post on the basis of a no objection certificate issued
by
by
the owner.
landowners. So he is not the landowner. So, Your Lordship,
Okay.
this should not be delayed further.
Lordship, so far as the appointment of the private respondent is concerned,
Mm.
this honorable court has not said that he should be appointed in that particular vacancy. Compassionate appointment can be anywhere in the state. But when there is a right of the landowner and a compassionate appointment, then landowner will not have any right in the other place except in that particular office. But the compassionate appointment can be anywhere. Even in Kohima, they can be appointed. But then, by appointing that in that particular office, my right for consideration has been deprived.
No, he is not the landowner.
There is, of course, a question of fact.
Yes.
Yes.
Anyway, so
So, if since my learned advocate, government advocate is asking for time, let us fix next week for disposal.
in the admission column,
Yes.
Next week, Lord,
Otherwise,
I'm not in
in
the
fact,
state, out of station.
This
So
this
let
is to
it be up
disposed
to
of
2
today.
weeks. My
Because
learned
last
friend has
time-
waited for a considerable time. So 1 week will not make much difference.
In fact, this is supposed to be disposed of today. Because last time, for something, I could not attend. But his lordship was about to dispose. But he wants both the senior councils. So it is being
Yes.
fixed today.
right? Okay. Mr. C.T. Jamil, Plan Senior Advocate,
Assisted by
Assisted
IM.
by I.M. Chen. also heard. Mr. Arigan. Learned senior advocate, assisted by for respondent number five.
Five.
And Mr. Zimomi. Learned counsel, learned government advocate, staff is paid for by the learned counsel for the petitioner and the government advocate. List this matter after 2 weeks. Okay.
May I please, Your Honor?
Yes,
My lord, I beg to mention item number 27, my lord. 27, my lord. My lord, I pray that this matter can be taken up on Tuesday, my lord. Do they have some difficulties? Item number 27.
you have a respondent.
Yes, Lordship, I'm for respondent number 5, Lordship.
You have no objection.
No objection.
Okay,
My apologies for respondent number 4, Lordship.
you're for.
Lordship.
Okay. Is prayed for by Mr.
And Longkoma, my lord.
Sorry, learned counsel for the petitioner. And to which Miss
Mika,
Ah.
Lordship.
has no objection, comma, list this matter after,
But
Next week.
Next week.
next week, okay.
May I please, Your Lordship?
Yes,
Lordship, I beg to mention item number 8, Your Lordship.
Tim,
Number 8. Lordship, here the private respondents, they have filed their affidavit, Your Lordship. Lordship, pleadings have been completed. If the matter can come up on 9, Your Lordship, for hearing, Your Lordship.
okay. Mr.
M. Solo, Your.
Learned counsel for the petitioner and Miss Mary, learned government advocate. No, it's a
PP.
criminal PP,
Your Lordship.
PP, huh?
Your Lordship, consent have been taken from the private respondents, Your Lordship, from the private respondents.
Okay. It is submitted that the pleadings have been completed and the matter is ready for hearing. List this matter for hearing.
9/5, Your Lordship. 9
Nine.
May,
Okay, matter for hearing on 9/5.
March of March.
Is prayed, huh? Is prayed.
May I please, Your Lordship? Your
Yes,
Lordship, I beg to mention item number 10. Here, we'll file the affidavit in reply to the state as well as respondent number 7 in the course of the day.
you have to file.
Yeah, within the course of the day, I will file my affidavit.
Okay. You're for?
For
The respondent.
number 7.
Okay. Miss
Ace Cheben.
Learned counsel for the petitioner. Today,
Yes, Your Lordship.
submits that she is filing affidavit in reply to the affidavit filed by the respondent
7.
during the course of the day's stop. Miss
Asarutsa.
Learned counsel for the respondent number 7 is present hosting. This is in the admissions. Okay, list this matter after,
A week.
Hmm?
A week, Your Lordship.
okay, a week, okay.
Yes, sir.
Yes,
Yes, Lordship. Lordship, I beg to mention item number 20 and 21, Lordship. 20 and 21, on behalf of Mawsum, Lordship.
28,
20 and 21,
20 and 21.
Lordship. Lordship, here I'm here to file my counter, so kindly grant me 4 weeks' time, Lordship.
Okay. Mr. Supong Wali, Learned counsel for the petitioner is present. Miss
S. Chang,
Learned counsel for the respondent.
for the state respondents, Lordship.
Hmm?
For the state
The
respondents,
supposed state respondent prays for and is granted. How much time?
4 weeks.
4 weeks time. List this matter after 4 weeks. Okay.
Obliged, Lordship.
May it please the Lordship.
Yes.
May I beg to mention item 22 from the order listment.
Okay.
I'm appearing interim appearance on behalf of the respondent,
Hmm.
and I'll be filing my power during the course of the day. I may be allowed 4 weeks' time to file my affidavit in
Okay.
opposition.
Okay. Miss he is present. Learned counsel for the petitioner is present. Mr.
NK will come for the
Appeared.
respondent. NK will
I'm
come,
here. You can- Would appear on behalf of
the respondent.
all
All respondent.
all the respondent. And submits that he is filing his power today itself and prays for 4 weeks time to file affidavit. The prayer is allowed. List is matter after 4 weeks.
Most.
May I please, Your Lordship, I beg to mention item number 3, Lordship. If
Item
3,
3.
yes, Lordship. Lordship, if this matter can come up after 2 weeks, Lordship. I have the consent of the PP, Lordship.
You are for the petitioner.
Appellant, Lordship, yes.
You file under 389.
Lordship, yes, however, Lordship, since the paper book was ready, so the dishonorable court has directed to go for.
Let it be, let it come. Just we'll see the records and pass order, okay? Let it go, huh? Okay.
Please, Your Worship, I beg to mention item number 18 and 19. I'm for the respondent number 1 and 2. Your Worship, 2 weeks time will be granted so as to enable me to file the affidavit in opposition. 18 and 19.
Okay.
Lordship, as per the previous honorable court's order, we have taken steps upon the respondent through dusty service. And to that effect, we have filed our affidavit of service also.
You have taken steps.
Yes, and to that effect, we have filed our affidavit of service also.
Okay, Mr. Pacheco Forte, line counsel for the petitioner is present and submits that he has taken
Affidavit of service.
affidavit.
We have taken dusty service, Lordship.
Okay,
Yes.
already taken steps.
Yes, Lordship. And we
Okay,
have
he's
filed our affidavit of service.
filing today.
2-3 weeks, last 2 weeks back.
No, he has already taken a step upon the respondent by justice service and prays for some time to file affidavit to that effect. Huh?
No, Lordship, we have already filed affidavit of service.
Already filed.
Yes, Lordship.
So what do you want?
So it's mentioning, Lordship. So I just,
Okay, just he's present, huh? Pacheco Forte present, and Mr. Team Song, line counsel for.
Respondent number 1 and 2.
So 1 and 2. Prays for
2 weeks time
2 weeks time to
to
file
file affidavit in opposition.
affidavit in opposition. The prayer is allowed. List is matter after 2 weeks. Okay.
obliged, ma'am.
Your Lordship, I beg to mention item number 9, Your Lordship.
Yes,
I believe the matter may become after a week, Your Lordship.
you are for the petitioner.
Yes, Lordship.
Okay. Is prayed for by Mr. Supamwati Waling, line counsel for the petitioner. List is matter after
A week.
a week.
Yes, Lordship.
Miss Mary, line counsel for the respondent is also present. Okay.
Obliged.
Please, Your Lordship. Lordship, I beg to mention item number 5, 6, and 7, Lordship.
5, 6, and 7.
Lordship, in item number 6, Your Lordship, I have recently filed my Vaklanama here, Lordship.
You recently
So-
filed your Wakaldanama.
Yes, Lordship, for respondent number 1. So, Lordship, if I may be granted 4 weeks' time to file my objection to this criminal petition, Lordship.
Okay, Miss Luciano, appearing on behalf of respondent number
1, Lordship.
1, prays for
4 weeks' time may
4
be
weeks
given
time
to
to
me.
file a affidavit.
Affidavit in opposition, Lordship. My
Affidavit in opposition.
objection.
Stop. Mr. You are for?
For the petitioner, Lordship.
Okay, Mr. Sega Forte, line counsel for the petitioner is present.
Medovero.
Hmm?
Medovero.
Oh, sorry, Medovero, line counsel for the petitioner is also present. As prayed, you are also here.
And for respondent number 2.
Okay. Zimomi, line counsel for the respondent number 2 is also present. Stop. As prayed for by the line counsel for you are for respondent number
Number 1, Your Lordship.
number 1. List is matter after 3 weeks.
After
4
4 weeks, Lordship.
4 weeks. Okay.
Lordship, I am yet to receive a copy of this petition, so if copy may be.
In the meantime, Mr. Medovero shall furnish a copy of the petition to the line to Ms. Luciano, line counsel for the respondent number 6. Stop. And 5, who you are for? Respondent number?
I'm here also, I'm appearing for respondent number 1, Lordship. Here we have already filed our counter, Lordship.
So here Medovero is also
Yes,
in 5. You are also there
Yes, Lordship.
for the petitioner.
Yes, Lordship.
Okay. Mr. Medovirulani, counsel for the petitioner is present. You have no objection?
No, Lordship.
Ms. Luzino, Lani, counsel for the respondent number one, prays for listing this matter after
4 weeks, your lordship.
4 weeks. The prayer is allowed. Is the prayer and the prayer not being objected to by the land council for the petitioner is allowed. List this matter after 4 weeks. And in 7, what is your prayer?
Lordship, here, I'm not a party here in this.
It's an
It's an
anticipatory bail, Your Lordship.
anticipatory
AP,
bill.
AP, Lordship.
Abby, who is praying here? No, you have mentioned only 5 and 6.
No, 6, 7.
5 and 6, these are all connected matters, lordship. However, in item number 7,
7 also
only
connected.
state is the party.
Okay.
It's an anticipatory bail, lordship.
Yes, you are for the petitioner here.
No,
I'm for the petitioner, Lordship.
Meadow Vero is for the petition.
Okay, what do you want
Here,
here?
I'm not,
Yes.
What do you want?
Lordship, since it is in
It is
a
connected.
matter,
it
Oh,
can
they come
be
up
listed
next day.
after 4 weeks, lordship.
Okay, Mr. Medovirulani, counsel for the petitioner, and Mr. Jimom, you are also, yeah, okay, PP. Present as prayed for by the land council for the parties. List this matter after 4 weeks.
Lordship, it's an interim, Lordship.
Okay,
Yes.
in 7, the interim order passed earlier shall continue
Obliged.
till the next date,
Yep.
Okay,
Please, Your Lordship.
yes,
Lordship, on behalf of the council on record, this V. Debnath in item number 25. He's suddenly indisposed and he prays that the matter may be listed after 2 weeks.
okay, Mr.
I, Jamil.
Appearing on behalf of Mr. V. Devnath, land council for the appellant, submits that Mr. The appearing counsel, Mr. V. Devnath, is indisposed and prays for
2 weeks time, Lordship.
listing this matter after 2 weeks. Stop. Miss
Clear to the
4,
respondent number 6 and 7.
for respondent number 6 and 7 is present. Stop. As prayed, prayed for by, and as prayed, list this matter after 2 weeks.
2 weeks, Lord.
Okay.
Obliged.
For admission, item number 3.
Yes, yes. No? So who mentioned? Just
Yes, Lordship.
so
For the
you are for the
appellant.
petitioner only?
Yes, Lordship.
Any, so just information, when this accused or the convict was arrested
Lordship.
initially, how long he had been inside the custody?
Lordship, when he was arrested, while on trial, he was on bail, Lordship. However, after the conviction only, he was arrested. Lordship.
Okay, during the trial, he was out of,
Yes, Lordship.
okay, no, not inside.
No,
So
Lordship.
after conviction
After
only.
conviction only.
So how long he has been till date?
Lordship, I think,
Lordship, if the matter is to be taken, I'm informed by the petitioners that they are seeking time. Yesterday also they informed me, even this morning they informed me.
no, Lord. Yes, Lordship, we
Lordship,
did
so maybe
mention.
it will be released after some time, Lordship, after, something on. So I
When?
did not come prepared, Lordship. I did not come prepared, Lordship.
Okay. So it is her case. I was trying to, just for information, just one information. He has been convicted under 304,
Lordship,
part 1 or part 2?
part 2, Lordship.
Part 2.
Lordship.
And then he has been inside how many?
Lordship, after the conviction, it will be, I think, almost 1 and 8 months, something. He was rearrested on 10/11/22, Lordship. 10/11, Lordship.
23, now is almost 2 years.
Lordship.
Okay. So when do you want?
Lordship, 2 weeks, Lordship.
2 weeks.
Yeah, if your Lordship can dispose the IO.
No,
We have no issue, but
at one
since,
point,
yeah.
let it be discussed in 2 weeks' time. Why keep it for piecemeal, Lordship?
So IA we can take up.
No,
When?
Lordship, instead of taking up piecemeal, let it be disposed at one go, maybe after 2 weeks or whatever.
So because hearing might take a little longer.
Yes, Lordship.
IA can be disposed of in the meantime. Because IA is only for the suspension and then bail.
Lordship,
And in the here I've seen
yes,
if the conviction is under 304 part 2,
yes.
then you see the bail can be granted. I mean, the that can be suspended also if, of course, prima facie made out after hearing.
Lordship, so my prayer is leave alone the bail. If they have make out the case, let him be released, but take up at one piece, be it after 1 week, 2
Okay.
weeks,
So
whatever.
entire matter you want.
Yes, yes.
Okay.
So
Then
to their convenience.
well,
Lordship, after 2 weeks, Lordship.
after 2 weeks. Okay, Miss
Mika, Lordship.
Michaela, counsel for the applicant. Praise for listing this matter after
2 weeks, Lordship.
2 weeks. Mr. Angamelana PP is also present. He has prayed, list this matter after 2 weeks.
Lordship.
For admission, item number 4.
Yes,
May I please, your lordship. Lordship, on the last occasion, the lower court record was called.
record was called.
Yes. However, if your lordship may kindly allow me to explain the case in brief, and if you lordship may kindly take up the matter today.
Okay. So just a minute. This is for
Civil revision, your lordship.
have you received the trial court record? No. Record not yet received.
Lordship,
Hmm.
the issue is very limited actually.
Yes,
Okay,
So
what is this?
I agree with my learned friend's contention that my lord may be able to decide the matter on the records that is available also. It's very limited. It's only a
Okay.
question of law.
Okay. Hmm? What? I received the records. So, okay, in absence of record, it can be taken up, you mean to say?
Lordship, yes, that
Yes.
is.
Okay,
Right, yeah.
so what is this person?
Lordship, this civil revision is seeking to set aside the impugned order passed by the Honorable Civil Judge, Senior Division, dated 4/8/2023, Lordship, whereby the Honorable Civil Judge, Senior Division Dimapur failed to consider the period which has been excluded by the Honorable Supreme Court in due to COVID pandemic, Lordship. So the Honorable Supreme Court in
You are for respondent.
Yes, ma'am.
yes, Lordship.
So this is for,
Response.
so condemnation of delay
Yes,
has been
Lordship.
rejected.
Yes.
So you have any objection?
Yes, Lordship.
Okay,
My learned friend had filed an application for condemnation or for impleading the legal representatives as the plaintiff had died. However, at that point of time when the application was filed for implement of the LR, the condonation, a prayer for condonation was not raised, and therefore the court, the learned civil judge, was of the view that the period of limitation had expired, and therefore the application was dismissed. And subsequently,
according to you, that was not raised.
Lordship.
yes, Lordship.
The question,
According to me, the IA for implement of the LRs was dismissed, and therefore the suit had abated. And the position of law is most clear in this, that no speaking order is required as such, stating in black and white that the suit has abated. When the plaintiff has deceased and when the LRs are not impleaded, Lordship, I'll satisfy this court with.
no, I
petition
think in
also.
that case,
So
probably in that case, you said that they have also not raised.
yes, Lordship. And subsequently, after the application for implement was dismissed, they filed an application only under Section 5 of the Limitation Act, praying for condonation. So when the main suit had abated, the question of condonation, that IA by itself does not have legs to stand on. Therefore, my contention is that at best, the petitioners here, the plaintiffs in the civil court, ought to have filed an application under Order 22, Rule 8, which specifically states that when the application, when a suit abates, an application ought to be filed under Order 22, Rule 8. But my learned friend has filed this application under 115 CPC for revision and 227, Lordship. And 227, Lordship, I'll satisfy my Lord on this, that cannot be invoked impulsively when there are clear statutory provisions. So my contention is that my learned friend may approach the civil court under the relevant provision of law, Order 22, Rule 8. Lordship. That is my
Lordship, when I file my,
Okay.
yes, when I file my petition for substitution of the
Take
plaintiff,
your seat.
Lordship,
Take
the honorable court did not raise any issue while admitting my application, Lordship. I filed my petition as IAS civil number 86 of 22.
It is there.
Yes, Your Lordship.
You have annexed.
Yes, Your Lordship. Your Lordship, page 40 to 43. So, Your Lordship, I filed the IAA for substitution of the plaintiff, Your Lordship, and my application was IA was admitted by the Honorable Civil Court, and there was no
This is
issue.
for, this is page 40 is application for application under Order 22,
Yes, Lordship.
Rule 3. What is this Order 22 and Rule 3? For substitution.
Yes, Your Lordship. So when I filed this petition, the court has not raised any issue regarding the regarding the delay. So I was of the view, and my petition was heard on 2/8/23, Your Lordship. I filed my petition on.
No, just a minute. So at the time of filing this
Yes.
application under 22, Order 22, Rule 3,
Yes, Lordship.
they did not raise any objection.
Yes, Your Lordship.
What do you mean? Who count the delay? They accepted the.
Yes, there was no issue regarding the delay, and I was of the view that the court has considered the period that has been.
Whether this IA was heard.
It was heard on.
Notice was issued to the respondent.
Yes, Your Lordship.
Opposite party.
Yes,
Opposite
Lord-
party also did not raise any objection.
No, Your Lordship. And my petition was heard on 2nd of August 2023. I filed on 23 to 2022, and my petition was heard on 2nd August 2023, the next year. And there was no issue regarding the delay. However, at the time of hearing, when the order was passed by the Honorable Civil Court, my petition was rejected, stating that it is beyond limitation, Your Lordship. As such, I filed another IA, which I have annexed in my petition, Your Lordship, page 51 to 57. IA number NIL 2023 for condemnation of delay, where I have mentioned.
After rejection of this.
Yes, Lordship.
You filed for condemnation of delay.
Yes, because Lordship, at the time of my filing the petition, the court was not court did not raise any issue regarding the delay, Lordship. So I was of the view that the court has considered the period that has been.
During the hearing of this application, IA.
Yes.
Who raised objection? The opposite party raised objection, saying that there is a limit.
No,
it
the
is
court,
barred by
the
limitation.
court has
Court itself.
Yes. During the there was no issue regarding the delay, Lordship. But when the order
Where is
was
the
passed,
rejection order? Where is the rejection order?
Lordship, page 44 to 50, Lordship.
(44).
Yes, Lordship.
So this is petition. I'm asking for order. Is this the order?
Yes, Lordship, the impugn order.
Where is the operative portion by which the court has rejected? Can you just read?
Lordship, page 49, the last
49,
paragraph may
yes.
be relevant for this.
Whether you filed objection to this?
Lordship, in this IA for
Yes.
implement, yes, Lordship. Actually, the matter was argued, and before the civil court, I've also placed arguments, but it was not on the issue of limitation. And
Okay.
as my learned friend had pointed out,
Hmm.
the court was of the view at page 49, Lordship, that there was a delay of 753 days, and therefore the court had dismissed this application for implement of the LR, Lordship. And subsequently, after this was dismissed, another IA was filed under section 5, Lordship.
$753 days.
Yes, Lordship. However, if the Honorable Supreme Court has excluded the period from between 15
Just-
three
just a-
2020,
just a minute,
yes.
So this is initially, there was a delay and you have not explained. That is why here, in this case, probably. So you mean to say while calculating the delay, so the court did not take consider
Yes, Lordship.
the exclusion of the
Period between 15 3 2020 till 28 to 2022, Lordship.
so that will only reduce the day,
Yes, Lordship. So if
but then
that,
still. Hmm.
if that period is taken into consideration, Your Lordship, I'm well within the limitation period.
Is it?
Yes, Lordship.
So then now let us see your condonation. Thereafter, you file condonation petition.
Yes, Lordship.
Where is that?
Your Lordship, it's page 51 to 57. IAS number nil 2023.
So you prayed for condonation of delay of how many days?
The days which has been 700. Lordship, the court has mentioned 753 days.
Yes.
So I have filed the IA for condonation of delay, stating that if the court take into consideration of the Supreme Court order, I'm well within the limitation period, Lordship.
Where have you stated?
Lordship, page 55.
Just a minute, limitation.
Para 7, Lordship, which I have also mentioned the Supreme Court order.
Now then why you have filed this condonation? Then condonation of what?
Lordship, since my petition for
You mean to say that there was no delay in filing, according to you?
yes, Lordship,
Then why you have filed?
because my
Could have
petition,
challenged that order. Could have challenged that order.
however, that
Have you challenged that order? The rejection.
no, Lordship,
Because you say that there is no delay in filing this application.
yes, Lordship.
So then why you have filed instead of challenging? You should have challenged.
Lordship,
Then because this condonation of delay was not required if there was no delay.
yes, Lordship. Your Lordship, if I may.
Then you could have, what I'm saying is, could have
Yes,
filed,
Lordship.
challenged this order itself
Yes,
instead of
Lordship.
filing condonation of delay, which was no delay, condonation of no delay.
Yes, Lordship.
Then
Lordship, if I may be allowed to consult my other senior colleagues who was taking
that will
up
be
the
better
matter in the
because you
Supreme
have to
Court.
challenge that order.
Yes, Lordship.
Because you say that there is no delay. Then why condonation petition?
Yes, Lordship.
Not required.
Okay.
Challenge that order.
Yes, Lordship.
So she prays for some time. I think it's required. Miss
Nagalishwari, Lordship.
Milan counsel for the petitioner. Prays for how much time you want?
1 week, Lordship.
1 of time. Prays for adjournment of the matter, huh? For a week. So, Mr.
Alezokiri.
Yes. Alazukire, counsel for the respondent, sole respondent.
Lordship, no, only two of them, 1 and 2, respondent 1 and 2.
Okay. Respondents are is also present staff. Huh? Is pray for no, Miss so pray. Okay, is prayed, comma. List is matter after a week. Okay.
Much.
For admission, item number 11.
Elijah.
Yes.
May please your lordship.
Yes.
Lordship, the Leonard PP is busy in courtroom 1.
Okay.
So we can take up after some time.
So okay. So is any effective order to be passed? So today is listed for what?
Listed for hearing on.
You are for the petitioner. You are
Yes,
for
my
the
lord.
petitioner.
Yes, my lord. I'm for the applicant.
Applicant.
Yes, my lord.
You are protected by
I filed
interim
the
order
petition under 438.
438.
Yes,
Other-
seeking for anticipatory bail.
Yes. You
And
are
this honorable court by order dated 26/3/2024.
yes, you are protected by this 26 order.
Yes, my lord.
Okay. So I think record was called for or what?
A CD was called for, my lord.
CD was. Have we received CD? No.
A prosecutor might have received. The Leonard PP, she might have it.
Okay.
11
After
and
some
12
time.
After some time, my lord.
Okay. After some time.
Analogous item number 12 also.
11
and 12 analogous.
11 and
12.
12. After some time. Okay. Yes.
For orders, item number 13.
My Mr. Lordship,
Yes.
by court's order dated 9/4/2024, we have filed affidavit in respect to the dusty. Made a notice be deemed served.
You have taken step by Dusty.
Yes.
Already taken step.
Yes. And
Affidavit filed?
Yes, we have already. filed.
Affidavit also filed.
Yes.
So what is required to be done today? No one appears. Dusty upon respondent number 2.
Yes.
You are for?
Respondent for the other private respondents, Lordship. The respondent number 2 is different, Lordship. Yes.
Affidavit with regards to Dusty service upon respondent number 2 filed. No, Rust. taken justice service upon respondent number 2.
Yes.
How many respondents are there? You are for Mr. Mudaveri,
I'm just for the respondent number 3 to.
you are for 3.
Yes, Lordship, 3 to 5.
6 respondents.
6.
Yes.
So whether the other respondent appeared earlier?
No.
No, no one appeared.
Yes.
Just a minute. Huh? LCR also called for. And then, okay, Miss
Ayala Imchin.
I.
Ayala Imchin. I'm appearing on behalf of Tombok Pongoner.
Your name is also there. Not in the cause list.
Yes, I'm appearing on behalf of Tombok Pongoner.
For Pongner.
Yes.
No. Appears on behalf of Mr. Tompo Pongner, Line Counsel for the appellant. And submits that the appellant has taken steps upon respondent number 2 by a justice service and also filed affidavit to that effect. What about the other respondent?
Yeah, government respondent, Lordship.
Oh,
Yes.
the government.
Yes, Lordship. 1, 3, 4, and 5.
You are for respondent number
6, Lordship.
6. Huh?
Yes.
And also file the submits that she has affected justice service upon respondent number 2, and has filed an affidavit as a proof thereof. Stop. Mr. Medovoro appears on behalf of respondent number 3
Respondent number 6 on behalf of Sir P.P. Pon.
or 6.
Yes.
Okay. Stop. No one appears on behalf of the respondent number 2 and the state respondent. The record is also still awaited. The LCR is also still awaited. In view of the above, when do you want
After 2 weeks.
the case stand adjourn? List this matter after 2 weeks.
Lordship, there is an interim.
Interim.
Yeah.
The interim order passed earlier shall continue till the next date. Okay.
Obliged, Madam.
For orders, item number 14.
Right, Mr. Lordship.
Yes.
Lordship service is awaited.
Hmm?
Service is awaited upon respondent number 1, 2, and 3.
Okay. Miss.
Tuyekrulo.
Hmm?
Tuyekrulo.
Tuyekrulu. Land counsel for the appellant is present. The office note dated 22/4/2024 reflect that the service upon the respondent number 1, 2, and 3 is still awaited. Stop. In view of the above, list this matter after
4 weeks.
4 weeks. Okay.
For orders, item number 15.
Kindly allow us 1 week time to file IE for implement of new respondent.
Mr.
Manan.
One.
Manan.
1 and 3. Who?
Lordship,
Your good name?
Manan.
Mane.
Your Lordship, I'm appearing on behalf of the council for the petition.
Your name is not there in the
Yes,
closed
ma'am.
list.
Yes,
It's not there.
yes, my lord.
Okay. Mr. Mane Lanak now appearing on behalf of Mr.
Sandy
Sentianger.
Younger.
Sentianger, Lanak counsel for the petitioner. Raise 4 and is allowed. How much time?
1 week time.
1 week time to
File IE
file IA
for implement
for
of new
implement of
new respondent.
the new implement of the new respondent.
Yes, your Lordship.
Okay, the prayer is allowed. List is made after 2 weeks.
Obliged, your Lordship.
For orders, item number 16.
May I please, Your Lordship?
Yes.
Lordship, the service is completed, so the matter may be listed for hearing.
Miss.
To Yakrula, on behalf of V. Devnath,
Appearing on behalf of Mr. V. Devnath, Lara counsel for the appellant.
I'm for respondent number 1, Lordship.
No, not appearing, huh? Appear on behalf of Mr. B. Devnath, Lara counsel for the appellant, huh? And Mr.
Lakshmi Pam, Lordship, for respondent 1.
Also heard, Mr. You are for Pongner?
Lordship.
Okay. Appearing on behalf of Mr. Pongner, Lara counsel for the respondent number?
1, Lordship.
1, stop, huh? The Lara counsel for the party submits that the pleadings are completed. The matter is ready for hearing.
Lordship, the IA for stay is yet to be disposed of, Lordship.
IA?
Yes.
Just a minute. Here, this is in the order column. List is matter for admission hearing. Okay. IA is?
For stay of the impugned judgment and order, Lordship.
Stay of?
Of the judgment and order.
Okay. Then it has to be admitted. And then stay if granted, you have to deposit 50%.
Lordship.
Ready?
Lordship, I'm not aware about that one.
Ah.
Yes, because the leading counsel is not.
No. So in that case, what we can do is the matter can be admitted. And then since the appeal will be admitted, and since the appeal is admitted, then in the stay can be granted on the condition that you deposit 50% of the awarded amount. Obtain instruction. That is the procedure. So because this can be straight away admitted for hearing, huh?
Yes, sir.
You obtain instruction, let it be listed tomorrow. Tell him that this matter will be admitted and the stay will be granted, provided you deposit 50% of the awarded amount. Will pass order tomorrow.
No, Your Lordship, after
When?
2 weeks.
After?
2 weeks.
Lordship,
Lordship, because
is an MSA appeal, Lordship.
That is why I'm saying.
After tomorrow, if they can.
no, Your
If
Lordship,
ready, because this you have filed, I'm ready to admit.
Mr. V.
They have not.
Yes.
So obtain instruction next week.
Okay, Your Lordship.
Okay, as prayed for by Ms. So-and-so, appearing on behalf of Mr. Devnath, Land Council for the appellant. List this matter next week. You obtain instruction. Tell him the court is ready to admit
Yes, Lordship.
and also grant stay, ready to admit for hearing straight away, and to grant stay on the condition that the appellant deposit 50% of the awarded amount. Okay.
Yes, Lordship.
Obliged, Lordship.
His name, present.
For hearing, item number 26.
Yes,
May I please, your lordship?
yes.
My lord, in this matter, one IA is still pending.
IA,
Yes, your lordship. This is for stay
IA
of the,
223.
yes, your lordship.
What is that for?
Stay of the judgment in order. We've already deposited the amount, 50% of the amount.
You have already deposited.
Yes, but it's
On
not disposed.
what basis?
As per the order, honorable court order,
Not yet disposed.
not yet disposed.
IA.
IA.
Just a minute, huh? You have a record of
Yes,
deposition.
yes. And 2/11/23, we've deposited the check with the registry.
Do you have the record of deposition?
Yes, I have the check number.
Check number.
Check number 1424.
Anywhere, let me see, just anywhere reflected in the order, in the office note.
Yes, ma'am. What I will mention.
Okay, 50% it appears you have deposited.
Yes, lordship, they have deposited.
I have.
You have also withdrawn.
Yes, yes.
So, no stay.
No stay.
Okay, so we'll dispose of this one. Just a minute, records, okay. Okay. Miss
Mua Chung.
Mua
Mua Chung La.
Mua Jungla, Land Council for the appellant. Also, Mr.
Lucknow from lordship.
Lakney form, Land Council for the respondent number 1 and 2.
Lordship.
Staff, para. Since the appeal has already been admitted.
Yes, you.
Okay, since the connected appeal has already been admitted, the operation of the impugn, where is the impugn order? Impugn judgment and award dated when it was? Judgment and award dated. Have you annexed?
Yes, your lordship.
Dated
Dated 31.
31/5/2022, passed by the Motor Accident Claim Tribunal, Mokokchung, Nagaland, in MSC case number 9 of 2020. Is stayed. The operation is suspended. Hereby suspended till the disposal of the appeal. Okay. Was there any order to deposit 50% of the?
Yes, your lordship.
There was an order.
Yes, your lordship.
Where?
So 9/10/23.
In the main case or in the IA? That order? 9/10?
9/10/2023.
In the IA or in the main case?
In the IA 140.
Or 9/10/2023. Okay, that is there, 50% deposit, but then no stay, no?
Yes.
Okay, then just change it, huh? Hard board, huh? Hmm. Okay, since the applicant has already deposited 50% of the awarded total awarded amount before the registry of this court, and the same has also been withdrawn by the respondent. Respondent claimant.
Claimant respondent. One.
Okay, claimant, okay, respondent, claimant, respondent. The and then as per the order dated 9/10/2023, comma, the operation of the impugn that will come again, huh? Impugn judgment and award dated so and so, passing so and so, that will repeat, huh? Shall stay, is hereby stayed. Yes, shall remain stayed till the disposal of the appeal. With the above this, IA stands disposed of. Okay. And in the main, huh? Are present. Present, huh? By which order the matter was admitted? Yes, it is admitted. Okay. Both present, huh? Present of the appellant, Miss so and so, and counsel for the appellant, and Mr. so and so, and counsel for the respondent number 2 and 2, huh? Yeah, 1 and 2. Stop. So service completed. What about respondent number 3?
Respondent number 3 will found the substituted service and will file the affidavit also on 23/24.
No one appears. How many respondents total?
3, Lordship.
3.
Okay. No one appears on behalf of respondent number 3. So when do you want? Now this will be listed for hearing. Since they have also filed affidavit. This is for hearing or?
Yeah, this is for hearing.
Okay. You're ready for hearing?
No, Lordship, actually my senior, he will be
Okay.
giving the submission. He's busy at courtroom number 1 in certain hearing item.
Okay. When do you want?
So it's up to you.
After a week, Lordship.
As prayed for by the learned counsel for the respondent, list this matter after a week.
From the supplementary cost list for hearing item number 28.
May I please, Your Lordship?
Yes.
Your Lordship, this petition has been filed challenging the appointment order dated 7/8/2014 of the respondent number 5.
Whether this matter was admitted?
Yes, Your Lordship.
When? I think not yet admitted. I didn't see the order of admission. It is yet to be admitted, it appears. I think it has been listed for the, and in the last order also it says that list for admission hearing. It has to be admitted first.
I think your lordship, it's already, yes. This
Where, by which order?
Lordship, this is a writ matter. I don't think any formal order will be required for admitting the matter, I think, Your Lordship. Unless it's an
Writ
appeal,
petition?
yes, unless it's an appeal or a review.
Why admission not
Notice has
required?
been completed, pleadings have been completed. I think you can take it up.
It has to be listed on hearing, in hearing then, for
Admission,
hearing.
we can dispose it off at the admission stage.
Admission.
Yes, Your
So,
Lordship.
can we dispose of today?
Yes, yes, yes.
Both are ready.
Yeah, parties are.
What is this matter about then?
Your lordship, this matter is regarding the appointment of grade 4 post. Lordship. Appointment of a grade 4 post. Your lordship, this petition was filed challenging the appointment of the respondent number 5 to the post of medical attendant at Public Health Center Yongwinson under under CMO Mokokchung. Your lordship, the petitioner is aggrieved as the appointment has been made by the respondent authority without conducting any selection process and which is in violation of the constitutional scheme of public employment. Your lordship, the petitioner on earlier occasion had also filed a writ petition, which was being numbered as WBC number.
No, so you are aggrieved by which order you said?
By the appointment order of the respondent number 57.
Where do we find that?
Annexure C, page number 14.
You are aggrieved by this annexure C.
Yes, Your Lordship.
Just let us see.
Your Lordship, the petitioner on earlier occasion had also filed a writ petition.
Just a minute, let us see. This is the appointment of the respondent.
Of the respondent number 5.
Respondent number 5. Just a minute. So this was appointed when it was appointed? 2000?
2014.
2014.
Yes, Your Lordship.
And then you have filed this writ petition?
Your Lordship, on earlier occasion.
2019.
Yes, Your Lordship. Your Lordship, on earlier occasion I filed a writ petition.
Against this?
No, before this. In the year 2015, which was being numbered as WBC number 115 before this honorable.
No. Against this appointment is in the year 2014.
Against this, I have filed a writ petition in the year 2015.
15. Against this order?
Yes, Your Lordship.
What happened then?
Challenging the appointment of the respondent number 5 as well as praying for appointment on the basis of land ownership. Your Lordship. However, during the pendency of the writ petition, the state government, by notification dated 5/3/2018, had framed a policy. Your Lordship, a copy of the said notification is annexed as Annexure I, page number 47.
Annexure?
Annexure I, page
Just a
number
minute,
47 to the writ petition.
Just a minute. You are aggrieved by this 2014. Just a minute. This is impin order is dated 6/8. So agree by this. Earlier you filed writ petition.
Yes, Your Lordship.
In which year?
In the year 2015.
Where do we find that? Have we called for the LCR? Not LCR, the records.
No, Your Lordship, I have annexed a copy of the writ petition.
No, this is not of course writ petition. See the, you have annexed the copy of the writ petition also.
Yes, yes, Your Lordship.
Okay, page 2015, page 25.
Your Lordship, I have an annex. Your Lordship,
No, this 2015.
Your Lordship, annexure H, page number 22.
20?
22.
2.
22. Annexure H.
Okay, just a minute. Huh? So why this writ petition you have challenged?
The appointment of the
Same
respondent,
impugn order
uh,
dated 6/8/2014.
7/8, 7/8,
Or
2000.
7/8. So where have you mentioned, just a minute? Can you just show me where have you mentioned challenging? Appointment order, you have challenged. Okay,
And also praying for appointment on the basis of land ownership on the earlier writ petition, Your Lordship.
on the,
The earlier writ petition was filed challenging the appointment of the respondent number 5, as well as praying for appointment on the basis of land ownership.
okay,
Your Lordship, during the pendency of the writ petition, the state government, by notification dated 5/3/2018, had framed a policy with regard to appointment to grade 4 posts under government of Nagaland on land ownership basis. And Your Lordship, post 3 sub-post C of the said
so during the pendency of this, the earlier writ petition, the state has framed policy.
Yes,
Where do we find?
Your Lordship, annexure I, page number 47.
Page 47.
Yes, Your Lordship. Your
What is
Lordship,
this? Just a minute. 47 is. Notification dated
5/3/2018.
Okay, so your relevant portion is
Clause 3, sub-clause C.
what it says.
Your Lordship, the clause 3, sub-clause 3 of the said notification clearly lays down that the employment of landowner, if permitted by a verifiable and valid agreement, is limited to the person first appointed as landowner. And Your Lordship, one Shrimati Tushimanla has been already appointed on the basis of land ownership under the PHC Yong Imson. So this was the case of the petitioner that the petitioner cannot be appointed to the post of medical attendant. Therefore, by order dated 28/2/2019, this honorable court was pleased to allow the petitioner to withdraw the petition with the liberty to file.
Okay, when did you withdraw?
28/9/2019, Your Lordship. Annexure J, page number 50.
Yes, you withdrawn
Yes, Your Lordship.
with liberty to
File afresh.
file afresh.
And
Okay.
Your Lordship, with this liberty, I filed the instant writ petition. Praying for-
Thereafter,
Thereafter, I filed this writ petition,
why?
praying, because Your Lordship, the post, the post, by the respondent number 5, the post held by him is a public post.
No, respondent number 5 was appointed in the year 2014 only.
Yes, Your Lordship.
So against that you have filed writ petition.
Yes, Your
That
Lordship.
was withdrawn.
Yes,
Then why against again this?
because Your Lordship.
The same respondent number 5 only.
Yes, Your Lordship.
Why?
Your Lordship, the earlier petition was filed praying for appointment on the basis of land ownership because the respondent number 5 is not a landowner. And he was appointed on the basis of land ownership, Your Lordship. Because
So,
he
but
has,
in the earlier challenge, when you filed writ petition in the year 2015,
yes,
challenge was in the same challenge was made that he is not the landowner.
yes, Your Lordship.
Okay, then why?
But Your Lordship, since the post has been already filled up on the basis of land ownership, I have to withdraw the earlier writ petition and file this petition challenging the appointment of the respondent number 5.
Earlier challenge was on what basis? Challenge against the appointment of respondent number 5 was on what basis? Your challenge was saying what? You are agree by the order dated 7/8/2014.
Yes, Your Lordship.
So you challenge on what basis?
Because he is not a landowner, Your Lordship.
Landowner. And this time?
This time, Your Lordship, praying to advertise the said post, since the post is only, the policy has already been availed by the petition, by the landowner. The post held by the respondent number 5 is a public post. So it has to be advertised as per the scheme of public employment.
So, okay, the earlier challenge was based on that landowner.
Yes, Lord.
Now we are challenging the appointment that since he is also not entitled, respondent number 5 is also not entitled.
Yes,
So it
Lordship.
should be
The post
advertised.
should be advertised. And
Okay. So let us see your prayer. To set aside
yes, Your Lordship, to set aside the appointment order of the respondent number
and
5
to advertise.
and to advertise. And I may be given a chance to participate in the selection processes.
Hmm. Yes. So,
My learned friend has not projected the case from its proper perspective. It's like this. I was appointed as on the basis of the land ownership. By making a misleading statement in the writ petition, initially which they have challenged in 2015. A misleading statement has been made that I am not a landowner. Therefore, my appointment should be interfered with. In that case, government has filed affidavit because we are all descendants of one. And government affidavit in the earlier case said that they have already got the appointment also. But we have not been offered any appointment. Therefore, I was appointed on the basis of landowner, respondent number 5.
Okay.
Government affidavit has clearly mentioned that I have been appointed, respondent number 5 has been appointed on the basis of land ownership. That is the reason why the writ petitioner has withdrawn the earlier writ petition, which was filed in 2015. That was the ground. Now, by filing the subsequent writ petition, they have totally changed the approach. Approach is now my appointment should be interfered with and it should be advertised. In order to get an order from this honorable court, first thing first, petitioner should approach the honorable court not only with a clean hand, but with a clean heart. Initially, they have claimed the appointment by making a misleading statement that I am not the landowner. I am a landowner, and the government affidavit has clearly stated that that is how they have withdrawn the first writ petition. By filing the second writ petition in 2019, they have challenged the appointment of respondent number 5. We filed affidavit in opposition. And we contended that, look, earlier you have challenged my appointment on the ground that I'm not the landowner. But then government affidavit said that respondent number 5 has been appointed on the basis of landowner. That is how you have withdrawn the writ petition. In the subsequent writ petition, they are seeking 2 prayers. One, to set aside and quash my appointment on the ground that I'm not a landowner. Again. Secondly,
no, this time she says that
it
not
should be
on the basis.
advertised. It should be advertised.
It should be advertised because by a notification, government notification 2018,
yes,
the landowner is not entitled, no longer entitled.
That is not correct.
Is entitled to only one.
It is
to only one.
Only one.
In a
According to
family.
you,
And
the
that has been
one
availed.
has already availed.
Availed,
And this is
They
the
have
second
availed.
one.
Already availed.
Yes.
They have already availed. But we have not got the appointment. Therefore, I have a right to be considered for appointment.
Now, who availed earlier?
In terms of
Just a
the
minute. Just clarification.
petition.
Who availed earlier? With
One Shrimati to Shimala.
okay. So you know that earlier already availed. So this, according to you, as per the notification of the government notification,
Yes.
the second one,
As per the notification, I was
the present respondent is not entitled as to be appointed
on the
basis of the land ownership.
Your Lordship. And
Okay.
Your Lordship,
So that is her contention.
Your
government
Lordship,
affidavit
there's-
clearly stated
Okay.
that I have been appointed on the basis of land ownership.
Yes.
And during the course of the hearing, this honorable court has issued a direction to the government because they have been contending that since the beginning. Therefore, this honorable court wanted to know from the government who is the employer, who is on what basis you have appointed. Then government came with an affidavit that respondent number 5 has been appointed on the basis of the land ownership. Now, the writ petitioner doesn't want that. To interfere with my appointment.
Now, government says, despite of the notification issued in the year 2018, now in the affidavit says that on the basis of the land ownership,
yes,
the respondent number 5 has been appointed.
Because what 2018 notification says, if there is provision in the agreement to provide appointment to the land ownership, this should be considered. If there is confusion or there is no clear agreement to that effect, then a direction should be issued to the deputy commissioner to make verification whether the person who is claiming is a genuine land owner or not, and the appointment will be made on the basis of the report submitted by the deputy commissioner. So this had a 2018 notification, and the appointment will be limited to only one appointment. It cannot be in perpetuity. That is the 2018 notification. Now, in a situation, 2-3 land owners have been acquired by the government and set up one institution, for example, a school. When a school is open, hostels are also there, staff quarters are also there. So 2-3 landowners are there. If I'm A, I get appointment. B and C are also there to consider their case. But that will be confined only to one each.
Okay.
Suppose.
If can you just see? Can you just see? If it
in the notification.
In the notification,
it was not explained.
Yes.
But
it says only one.
It gives right to the landowners.
Yes.
It gives right to the landowners to be considered for appointment. And the government affidavit is very clear that I have been appointed on the basis of land ownership. Then what is left to be considered? By making a false allegation, by saying that I'm not the landowner, initial writ petition was filed in that manner. In the first writ petition, the writ petitioner has nowhere stated that let the post be advertised. Nowhere. If there is, then let them show. That was not their case initially when the writ petition was filed. How that was filed, I am not one of the landowners. That is what they have made the statement. But the government affidavit has clearly said that I have been, respondent number 5 has been appointed on the basis of landowner.
So they withdrawn.
Therefore, they have withdrawn. And now, by filing the subsequent writ petition, they are coming with a plea that it is a public post, it should be advertised. But again, there is another notification in 2023, which restricts advertisement, which has exempted the advertisement when it is a case of land ownership. Therefore,
Have you annexed that one?
No, there is one government notification, Lordship.
No, have you annexed?
Latest.
You, I think, need to bring it on record. Because her basic
After filing the
Base
case,
for a challenge
after
that-
filing the affidavit, only this notification came during the pendency of.
I think this is a important document.
Yes.
You need to bring it on record.
We are placing before the honorable court.
Now, just one minute. Now, his appointment is in the year 2014 only.
Yes, Your Lordship.
The notification, government notification came only in the year 2018.
Yes, Your Lordship.
So that is, appointment is prior to the government notification. It was already done. So what do you say in this?
Your
Because
Lordship, this notification was brought to the notice of the court and this honorable court.
no, brought to the notice, of course, in the year after that
I was,
only 2019 only.
Yes, and I was.
But the issuance of this notification also came out only in the year after 4 years of his appointment, respondent number 5's appointment. After more than 4 years. So does it have a can it have a retrospective effect, the government notification?
Your Lordship, since according to the notification, since the appointment on the basis of land ownership has been availed, I had to withdraw the writ petition, Your Lordship. Because,
I need a clarification on the point that since the appointment of respondent number 5 is in the year 2014 only.
Right. And Your Lordship, the respondent number 5 is not a landowner. Regarding this issue, Your Lordship, I have.
But then the government says in his affidavit, according to his submission,
Your Lordship,
says that he has been appointed, respondent number 5 has been appointed on the basis of land ownership.
Your Lordship, may you please kindly refer to Annexure D, page number 15, Your Lordship.
Annexure
Annexure D,
D.
page number 16.
What is that?
Because Your Lordship, the respondent number 5, while submitting his application for appointment, had submitted a forged land ownership certificate. And regarding the issue, the village council, the chairman of the village council had submitted a application.
So this is the page 16 is annex.
It's a type copy, Your Lordship.
Okay. Annexure D.
Translated type copy, Your Lordship. To the principal director, Kohima, Nagaland. We, the Yongimson Village Council, had held a meeting and would like to inform you what we had discussed. That Shri Lanutushi, son of Markangpa, in order to work in Yongimson Sub-Center has written in the council writing back that they are the landowner of that said plot of land. But we would like to inform and clarify you that they are not the landowner of that said land. And also, without the knowledge of the Yongimson Village Council, he had misused the writing pad and forged the signature of the members as well. And therefore, we, the Yongimson Village Council, had held a meeting on 5/9/2014 and had taken befitting action against them. This is for kind information. And Your Lordship, Annexure E, page number 17. The chairman has also written a representation regarding the issue.
Annexure?
Annexure E, batch number
What is
17.
this?
This is also a representation to the principal director.
Who appointed the respondent number 5? Principal director?
Yeah, by the respondent authority.
The respondent authority means who? Principal director?
Principal director. Commissioners. Principal director.
Just where is the appointment order?
Annexure C, page number 14.
Principal director, yes. Principal director is the appointing.
The issue was brought to the notice of the
Just a minute.
principal director also.
Principal director, health and family. Okay.
So he
So
got
this
the
E,
issue.
annexure E, what is this E? Complaint.
Yes, Your Lordship, the representation to the principal director.
Complaint against two. This is commissioner and secretary. Just a minute.
And on behalf of the landowner, also Your Lordship, prayer for cancellation order has been submitted to the principal director also on behalf of the landowner. Your Lordship, it's has annexure F, page number 19.
Just a minute. This was written by Chairman. Who is this Chairman? Yong Sen.
Village Council.
So this is not the landowner.
No.
Okay.
On behalf of the landowner, Your Lordship, annexure F.
No, just E. What is E? Two appointment made at Yong Sen. What is this annexure? Page 43, annexure E.
Page 43, annexure E.
Is it connected to this case?
Page 43, Your Lordship.
You have just referred.
It's a complaint forwarded by the principal director to the commissioner secretary.
The appointment of complaint against whose appointment?
Against the appointment of the responder 5 and 1
No, principal himself has appointed.
Yes, Your Lordship.
So this is complaint against the appointment.
Yes, yeah.
By the principal.
This matter, this annexure was annexed in the earlier read petition.
No. How this is connected?
Because Your Lordship, I have annexed the earlier read petition. That's it.
Connected? How this is connected with this case?
Because the village council and even the landowners, they have submitted a complaint to the principal director. So Your Lordship, the principal director has forwarded the application.
Forwarded application to the commissioner.
Commissioner, Your Lordship.
But
however, the case of the petitioner was not considered, Your Lordship. Though he is the landowner. And Your Lordship, the state council, he has filed an additional affidavit stating that
just a minute. And then you have referred annexure F also. What is this annexure F?
Annexure F is prayer for cancellation on behalf of the landowner. Prayer for cancellation order of the respondent number 5. This application was submitted on behalf of the landowner to the principal director.
Saying what?
Stating that the present PHC is constructed in our land. And Your Lordship, point 2, Mr. Lanutushi, that's the respondent number 5, was appointed in the vacant post of Mr. Imitimshi, medical attendant, retired on 13 November 2013, using false documents such as false village council chairman writing pad and seal, false landowner certificate, Since Mr. Lanutucci is not a landowner, the village council submitted a representation to the department for cancellation of his appointment. As point 3, as per the government rules norms, grade 4 is given to the landowner, provided if the land is not sold or compensation. Therefore, point 4, therefore, we the landowners request the department to cancel Mr. Lanutucci appointment order since he is not a landowner and instead demand the appointment of Mr. Ingkong Chupa, who is the rightful
Who is this,
landowner.
Ingkong Chuba?
Your Lordship, the petitioner.
Petitioner.
Yes, Your Lordship.
This was issued in the year 2014.
Yes, Your Lordship. And this document was annexed in the earlier with petition also. And Your Lordship, in the present with petition also, the State Council has filed an additional affidavit stating that the respondent number 5 was appointed on the basis of land documents are submitted by him. But Your Lordship, the documents submitted by the respondent number 5 are all forged and fake, Your Lordship. And regarding this issue, this Honorable Court right order dated 30/10/2013 had allowed the petitioner to file an additional affidavit, Your Lordship.
In this writ petition?
Yes, Your Lordship. Right order dated 30/10/2013, 2023.
30/10 to 20.
The additional affidavit is nothing but the earlier writ petition which was withdrawn.
No.
Same statement has been.
You have also filed reply.
Yes.
Your Lordship, I filed an additional affidavit reputing the land ownership of the respondent number 5.
Regarding the land ownership, Lordship, the matter was adjudicated before the DB's court. And DB's court has settled the matter. They have not challenged that order also.
Whether that
So it is not a
It's
it is
not
not an
related.
issue at all.
DB's decision has been annexed. Whether the decision of the DB's you have annexed.
Yes.
Have you challenged that? Because
No.
the land ownership is a, you see, question of fact. It involves question of fact, which this High Court cannot. And that will be decided by the trial court or the DBs or the local court. So if the local court has decided the land ownership, and then if he has been appointed on the basis of the land ownership, probably you need to challenge that order.
Or
Because
Your Lordship, it's a
then
different case.
unless you challenge that, then on the basis of the land ownership, or here you can't, it will be difficult for you to establish that he is not a land owner because the DB's court, the trial court, has decided
But Your Lordship,
in his favor.
this Honorable Court had allowed the petitioner to file a additional affidavit repeating the land ownership of the respondent number 5. Your Lordship, may you please kindly refer to the additional
Yes,
affidavit
where is it?
by the petitioner.
Additional affidavit filed by additional affidavit filed on behalf of the petitioner.
In
So
compliance
this was-
with the Honorable Court order.
Hmm.
Your Lordship, here
Yes.
I have annexed annexure 1, batch number 6. It's a no objection certificate.
Issued by, no objection.
Yeah.
Wha-
This no objection certificate was submitted by the respondent number 5 to the respondent authority while submitting his application for appointment. Your Lordship,
Just a minute.
here on behalf of the landowners, 3% they have endorsed the no objection certificate.
The 3%
Yes.
issued no objection certificate in whose favor?
On behalf of the respondent number 5.
In favor of respondent number 5,
Yes, Your Lordship.
saying that the respondent number 5 is then owner.
Yes, Your Lordship. But Your Lordship, may you kindly refer to Annexure 2, page number 7.
No, this no objection certificate is in favor of respondent number 5.
Yes, Your
Then
Lordship.
it is against you.
Yes, but Your Lordship, I want to bring
Okay. And then page.
Annexure 2, page number 8. This is a translated type copy.
Okay.
This is the statement of one of the signee of the no objection certificate.
No objection. This is also no objection certificate.
No. It's a statement.
Statement by?
Statement by one of the signee of the NOC.
Signatory in the NOC.
Yes, Aung Nokten.
Okay, what he has stated here then?
I Shri Aung Noklen states that on dated 21 August 2013, Mr. Lanutushi, for seeking a government job, had approached me with an application for signing. His signature was required from the descendants from the 3 forefathers. Therefore, I have signed on behalf of the clan descendants, but not on behalf of the landowner. When the descendants from the 2 forefathers were disputed at the court for an issue, there I have rightly testified and said that myself as well as they are not included in the land. When Lanuchupa is the grandfather of the petitioner lordship, occupied the Upper Kale, Lanuchupa had given 1 plot of land each to me and them. And this statement I have truly testified.
Okay, so this is in your favor again.
Yes, Your Lordship.
So
because Your Lordship.
Then the Learning Council for the respondent number 5 submits that the basis has already decided the lane to be in his favor.
No, Your Lordship.
Whether you were also present in the decision of the participated in the Dobasis decision.
Yes, yes, Your Lordship.
And you know that it was decided against you.
No, it was decided that the land belongs to the village because, Your Lordship, this land was donated by my grandfather to the village council.
Let us come to what is the decision according to you. What is the decision of the basis? Decision of the basis.
The decision says that the land was donated by the great grandfather of the petitioner, but after a few decades, the land had already been divided among the grandfathers, and the donated land where the present PHC is established has been donated by my grandfather to the village for developmental work without compensation. So I am the rightful landowner of the present PHC.
So the decision of the Dobas is in your favor, that means?
No, Your Lordship. The decision says that the land belongs to our great-grandfather.
Great-grandfather.
Late Nokchu, yeah. He is the founder of the village, just one of the founder.
Then you mean to say that it is not in his favor also?
Yes, Your Lordship, not in my favor, not in his favor also.
Lordship, we are all second cousins.
Not seconds, it's been so many decades.
We are the descendant of one person of
Nokchu.
But ultimately, what the Dobasis, the decision of the Dobasis says?
Dobasis said that yes, land has been donated
by my grandfather, Your Lordship.
The grandfather to the village. The village council is virtually the owner of the land now, but then original owners were our grandfather. My grandfather and their grandfather.
But the land has been divided few decades back, Your Lordship, and my grandfather has donated the land.
No, she says that it is neither in your favor nor in her favor. Is it correct?
Lordship.
It is in favor of both.
Yes.
Both are both the landowner.
Yes.
Then you cannot exclusively claim that you are the landowner. She is also owner.
So, how to decide and who should be the appropriate authority to say that? That matters. My appointment was up to the approval of the government, and by filing the writ petition, the writ petitioner have not challenged even the approval of the government. And we have taken a plea about the delay in leases and then misrepresentation of facts, and the basic order has not been challenged. Only the consequential order has been challenged. Therefore, without challenging the basic order, you cannot challenge that. Challenging only the consequential order cannot help. Therefore, in such a situation, the appointment cannot be in effect. Secondly, Lordship, my learned friend was referring to additional affidavit and all these things. Up to that, because the matter was heard from time to time on several occasions, ultimately, this Honorable Court was pleased to issue a direction to the government advocate in view of so many discrepancies on 23rd May 2023. This Honorable Court has directed the government to file a clear affidavit that has been filed. And in paragraph 2, very clearly government has stated, if I take your Lordship's attention to the additional affidavit of the government, because we are claiming something, they are claiming something, but ultimately, who is the owner? Who is the employer? It is the government. Who is the employer? So what government affidavit says is vital in a situation when there are contesting parties. So kindly come to paragraph 2, Lordship. The additional affidavit filed for and on behalf of the state respondents in compliance of the order dated 29/11/2022 and 23/5/2023.
Not affidavit in opposition.
No, additional affidavit.
Affidavit in opposition.
No, one additional
there.
in affidavit, Lordship. It has got only 4 paragraphs. Small, short affidavit, Lordship will find. And
Affidavit in opposition for respondent number 5.
An additional
Just a minute,
affidavit.
Affidavit in opposition for and on behalf of respondent number 1, 2.
In both letters, state respondents in compliance of
An affidavit in
order
reply. An affidavit in reply.
It will be towards in the bottom.
Yes, additional affidavit filed on behalf of respondent number.
No.
Respondent in compliance of order dated 29.
Yes.
Okay.
That is the one, Lordship.
Okay.
Kindly come to paragraph 2.
Yes.
Has your Lordship read it?
Yes.
Paragraph 2. That in compliance of Honorable Court order dated 29/11/2022 and 23/5/2023. This direction, these 2 orders are after the additional affidavit was filed by the lead petitioner, Lordship.
No, Your Lordship.
The deponent is humbly beg to state that the respondent number 5 was appointed based on the land ownership documents produced by him, whereas the case of the petitioner could not be considered due to the reason that the petitioner's family had already availed the opportunity for appointment on land ownership. So government memorandum will cover this. Therefore, it may be noted that there is no pick and choose policy, but have followed the due procedure while considering the case of the respondent number 5 and the petitioner. So that is enough.
So government
Your Lordship, this additional affidavit
the
was
affidavit of
filed
the
last
employer.
year. And this additional affidavit was filed this year in the month of March.
No, it was filed on 1st June 2023, Lordship.
Your Lordship, and this additional
Report was-
affidavit, it's filed this year in the month of March 2024. Because Your Lordship, this additional affidavit was filed in compliance to the Honorable Court Order 30/10/2023, by which the petitioner was allowed to file an additional affidavit, including the land ownership of the respondent number 5.
So this additional affidavit filed by the petitioner is after this additional affidavit
Yes.
filed by the government.
Yes, that is correct, Lordship.
Ah.
And by filing this affidavit, the same statement which they have made in the first week petition, which they have withdrawn. All the statements have been repeated in this affidavit.
No, Your Lordship, the annexures are
Which
different,
they
Your
have
Lordship.
withdrawn.
But you see, even prior to or but in this statement,
Because
that
Your Lordship,
the petitioner family had already availed. Here it says, the government says that you have already availed the opportunity for appointment on land ownership.
Yes, Your Lordship, it's been availed. So, Your Lordship, the post held by the respondent number 5 is a public post. So it's ought to be advertised.
No.
Per the constitution.
No, what I'm saying is, try and understand, one thing. because the government says that you already availed one post
Yes, Your Lordship.
on the basis of the land ownership.
Yes, Your Lordship.
Thereafter, in the year 2014, respondent number 5 had been appointed.
Appointed on the basis of land, forged land.
Again, on the basis of land ownership.
Yes,
Till
Your
then, this government notification 2018 did not come.
Lordship.
And that government notification came only after the appointment 2014,
Yes,
only
Your Lordship.
2018 only. So my query, I just wanted to know, so whether this government notification retrospectively affect the appointment of in the year 2014, because till 2014, 18, 1, 2, 3, 4, on the basis of land ownership, could have appointed 2, 3, 4, 5, 6, maybe. But then this notification came in the year 2018 only.
Your Lordship.
So can it have a retrospective effect?
Because Your Lordship,
Because you did not continue with that challenge. Because you are land owner, you have a right.
Yes,
You had a right to challenge actually.
Yes.
And if you had properly challenged the proper order, the roots, what Land Council for the petition respondent number 5 is submitting. So had you challenged all those, and had you not withdrawn, could have of course taken. But then now, since you have already withdrawn that one, now your challenge is on the basis of that this is a public post. And then because as per notification 2018, he can't be. But he has not been appointed after 2018. He was appointed prior to 2018 only. So that is my query.
But basing on this policy, I had withdrawn, Your Lordship.
So but when you withdrawn it, why you have withdrawn? Because you had a good case, because you are land owner, your great land belongs to your great grandfather. Should they file additional affidavit if there was some notification, something?
So, Your Lordship,
So you have to answer if it has a means a notification. This notification has a retrospective effect. The government has government is there.
Yes.
Yes.
My
What
lord,
does it say?
Moreover, my lord, additional affidavit was filed in compliance of honorable court order. In that affidavit, we have already clearly stated that respondent number 5 was appointed on land ownership basis. In that statement, the petitioner, they have not replied, means they have not countered. That means they have admitted.
You should have countered.
Yes, they have
that.
not filed any.
Because when the government says, government clearly stated that the petitioner, sorry, the respondent number 5 in 2014 year WPC 117. So when the government says that he has been appointed on the basis of land ownership, but since you have also claim over,
yes, Your Lordship,
you are a land owner and would have continued. So after that you withdraw.
Your Lordship, but the policy clearly states that on the basis of land ownership, only one family members can be availed.
No, that is only after
Your Lordship,
2018.
For that,
After 2018. But then he was appointed in the year 2014 only. After 2014, the government is clear. No 2% can be, or it cannot be appointed, perpetuated. It cannot be perpetuated. So only one, if one is availed from the family, entire family, so no 2%. So it is clear. Of course, after 2018, you are clear.
But Your Lordship, since the post held by the respondent number 5 is disputed before this court, so it's up to the court to decide.
But land ownership, then you say land ownership. So, but then government clearly stated, and then you also says that both are land owners. Even you are also entitled prior to 2018. But then after 2018, neither you nor he is entitled. After 2018,
yes,
both are not entitled.
Not
but
entitled.
Before, prior to 2018,
yes,
it appears you are also entitled. Could have continued with your petition.
My lord, in fact, the state government is maintaining the equality because since the petitioner is already
One family availed,
we are giving
other family.
chance
Now,
to other family.
Now that cannot also be continued
Yes.
after 2018.
Yes, yes, my lord.
It appears.
After 18.
So,
but Your Lordship, this present petition has been filed praying for.
No, since it is a public.
Since it's a public post, it is ought to be advertised.
So that is what I am asking. What I am seeking a clarification. So because after 18 you're right. You're absolutely right. After 18, it becomes a public post. The landowner doesn't have a claim after 2018. But then this is prior to 2018, 2014 only.
And my lord, the latest office memorandum has dispensed with regard to the advertisement.
So where, bring that also into the.
Yes.
What is the other document you have just presented? This is,
I have placed that, lordship.
okay, can you just place it in just small affidavit? I'll reserve it, otherwise, because, so that bring it on
We can do
record.
that. We can do that.
I've heard, but then on that day,
Lordship.
with this, next week only we'll fix. On that day, I'll just
Lordship.
pass order.
And meanwhile, I am placing one judgment on the ground that without challenging the basic order, challenging the consequential order cannot be entertained. So paragraph 22, lordship. Paragraph 22.
So this is with regards to the 2015 the writ petition.
This is the document. No. In the latest writ petition 2019, even here also, they have
did not challenge.
challenged the government approval order, which is the basic order. Basic and that
They did not challenge what?
basic order, the government approval order. Because my appointment is made only on the
Okay.
basis of the
There is an
government
approval also. Have you annexed?
Yes, page 21 in the affidavit in opposition of respondent number 5.
Just a minute.
It occurs 2014. Any appointment, government will verify, and then only when the government approval is complete, then the directorate will issue appointment.
Para, you said para?
In paragraph 6, I have stated, lordship. So, government is
So your submission would be that you were appointed on the basis of the approval, basis of the land ownership, and then the government approved by
ordered 5th August 2014. And that is the basic order, and that basic order has not been challenged. Only the consequential order has been. Page 21, lordship, of my affidavit, affidavit of respondent number 5.
Okay, this is the initial approval.
Yes. So basing on this, appointment order has been met. And this basic order has not been challenged by the writ petition. Therefore, challenging only the consequential order cannot be entertained. In view of the judgment and order passed by the Honorable Supreme Court.
Your Lordship, regarding the issue for not for not challenging the approval letter dated 5/8/2014, I may be allowed to refer to a section. Lordship. 2010 SEC, Volume 10.
What it says?
Your Lordship, para 12, Your Lordship. Here, Your Lordship, communication between two officers of the Department of the Government cannot be the subject matter of the writ petition, Your Lordship.
Para 12.
Para 12.
Yes.
Your Lordship, we fail to understand as to how the contents of such a communication between two officers of the Department of the Government can be the subject matter of the writ petition. The appellants would not have approached the High Court for the aforesaid relief sought by them. The petition was certainly not maintainable. Your Lordship, the letter dated 5/8/2014 is just a conveying letter between two heads of the department, Your Lordship. So, Your Lordship, it's just a communication between two officers of the department. And it cannot be a subject matter of the writ petition, Your Lordship. Your Lordship, I may also be allowed to refer.
Yes, because you might not know the existence of this order, this letter.
When they have challenged the appointment order, it is within their knowledge because appointment
Yes.
order has referred the government approval order. So
It's
they
just a-
cannot say that it was not within my knowledge. They have challenged the appointment order. Page
What your
24 of the writ petition also. Affidavit in opposition. Page 22 of my affidavit in opposition. First line. This is order dated 7 August 2014. Affidavit in opposition of respondent number 5. Page 22. This is the appointment order of the respondent number 5 on 7 August 2014. Page 22, annexure 7. Page 22, annexure 7. First 3 lines will be clear.
Page 20,
22.
22 is annexure C.
Annexure
Annexure 7, sorry.
Yes. In pursuance of government approval letter number so-and-so, dated 5th August 2014, that is at page 21, Shri M. Lanutushi, that is respondent number 5, is hereby temporarily appointed to the post of medical attendant at so-and-so, so-and-so. So, this is the ambient order which they have challenged. And they are very much aware that the appointment order has been issued in pursuance to the government approval order. And government approval order is the basic order which has not been challenged by the writ petitioner. And as I have referred the ruling of 2010 1 SEC, paragraph 22, I will just, it's a short paragraph, let me just read out the relevant paragraph also.
Paragraph?
Paragraph 22, the judgment which I have just referred
Yes,
to.
yes.
Also.
Yes. Yes.
It is a settled legal preposition that challenge to consequential order without challenging the basic order, statutory provisions on the basis of which the order has been passed cannot be entertained. Therefore, it is a legal obligation on the part of the party to challenge the basic order, and only if the same is found to be wrong, consequential order may be examined by so and so, so and so. So, the government approval order is the basic order, and the appointment order issued by the director is the consequential order. They have only challenged the consequential order. That is one.
Government approval order may not be available, easily available.
But it is mentioned in the approval order itself, a government appointment order itself.
Approval
So,
letter, Your Lordship, it's a
if it is
letter.
not available to them, it is the bounden duty of the writ petitioner to find out, to give an effort. And if they cannot find, then is there any amendment in the writ petition that in spite of the best effort of the petitioner, we could try to trace out the government approval order, but we could not get. There is no statement to that effect also. That means ignorantly they have not challenged. And Lordship is well aware that ignorance of law is no excuse. So they cannot take that plea now. My another point of submission, Lordship, because on Monday I may not be.
No, Monday, Tuesday, anyone. So that
yes,
let us bring it because that is important document.
Lordship.
So that need to be incorporated in the judgment. So file it, and not just if there is any clarification. Otherwise, no, not required also.
Yes.
Your Lordship, I may be allowed to
Let it
refer
be on Monday.
to another decision passed in the matter of Kartik Chandra Mandal and another reported in 2010, volume 2, SEC, batch number 422.
Earlier it
Actually, so this is regarding what?
Regarding,
Just a minute, huh?
yes, yeah,
2010,
SCC, volume 10.
2 SCC, 422, para
SCC, para 4, para 17 and 18,
17 and 18.
page 420.
Okay. What is that? What it says?
Para 17. The next issue that we are required to consider pertains to internal communications, which are relied upon by the respondents and which were also referred to by the tribunal as well as by the High Court. Expressing the aforesaid communications were exchanged between the officers at the level of board hierarchy only.
Yes,
Para
clear to
18.
that.
An order would be deemed to be a government order, as and when it is issued and publicized. Internal communication while processing a matter cannot be said to be orders issued by the competent authority unless they are issued in accordance with law. Your Lordship, and the approval letter dated 5/8/2013 is just a letter of conveying.
Yes, yes.
So-
Okay.
Unless it is conveyed, it will not be, never be appointed. As simple as that. Therefore, it has to be conveyed.
Yes.
Conveyed what? Approval has been conveyed.
Okay.
Monday is 29, Lordship. So
Monday, next week, any day. Not
Monday.
necessarily be on Monday.
Today is
We'll
Thursday.
fix,
So tomorrow, Friday, last working day. So let it be on Monday.
okay. Card. Mix. Miss
Nasla.
Land Council for the petitioner. I've also heard Mr. Jamil, Land Senate Council for the respondent number 5 and Mr.
E.T. Popcorn.
for
For
state
respondent number 1
respondent
to 4.
1 to 4 staff. Para. Land Council for the respondent number 5 placed office memorandum dated 3
3rd March 2022.
2022. And what is that? The other one?
This is the only one, Lord.
No.
Policy. That is a part of the petition. And affidavit in opposition.
No, the other document
Is
where the no, this is about companies. You said some other documents also, some notification, government notification which debar.
This is the one.
This is the one.
This has dispensed with the advertisement because the prayer of
Okay.
the petitioner is that the post should be advertised so that I can also compete.
Okay.
That is what you want. But then with regard to the appointment and the basis of landowners, this office memorandum has dispensed with the
and want to
advertisement.
bring it on records and praise for some time to bring it on record. Staff, by filing additional affidavit.
Yes.
Staff, the prayer is allowed. List is matter on Monday, Tuesday?
29.
29?
Yes, Lord.
Okay, okay. Further hearing. Further hearing. We'll say further hearing.
Yes,
of course, almost hard.
Listed on 29 as part heard, Lord.
It's part hard. Yes.
For admission, item numbers 11 and 12.
Yes.
Scanned copy of the CD has come, Your Lordship.
CD, okay.
Yeah.
So,
Page 14 and 15 is the statement of the applicant, Your Lordship.
okay. Just a minute, guys. Take this. In that document, keep it, staple it. Hmm.
Last two pages.
Last two pages.
Yes, 14 and 15.
Statement of the accused.
Accused.
The applicants.
The applicants.
Accused applicants.
Oh, applicant.
Yes. They have been cooperating with the investigating agency, my lord. And they have complied with all the terms and conditions set forth by this honorable court.
This is under what offense? Offense is
379.
My lord, theft.
okay. This Hirak Jyoti Deka is
Yes.
the accused.
Yes,
Yes,
one of the
applicant.
applicants. Yes.
And then other
And
is
the other
Sarajit.
one is Saranjit. Yes.
Saranjit Boro.
Yes, Saranjit Boro.
My lord, all total, there are 5 accused here. And 3 accused, they are already on bail.
Okay.
3 accused
So,
persons are already on bail.
were arrested.
Yes, my lord. Initially, in the FIR, only 3 accused were reflected.
Of all of those 3 accused.
Yes, they are already released on bail
Okay.
by the lower court.
They reveal the name probably.
Yes, my
Yes.
lord.
Name
During
of the present
investigation.
accused. And
During
on the basis
investigation.
of their statement, only this present accused has been arrested. But no, not arrested.
Not arrested.
Okay, just
Since the name had been revealed in the inquiry report,
okay, okay.
so they were apprehended in arrest.
Okay.
So
And
they
then
proposed this
some notice was issued to you, 141 CRPC? No.
No, my lord.
Only just you came to know that your
In
name.
the inquiry report, yes, my lord.
Okay.
No notice was issued.
So what happened after this? You are protected by this interim order 26.
26/3/2024.
Okay. So after that, you appeared before the
IO, investigating
IO,
officer.
and IO has recorded this statement. Whether you have you been also arrested?
No, my lord. IO has
No,
recorded
Your
my
Lordship,
statement.
their statement is at page 14 and 15. That's right. After the anticipatory bail has been granted, they have appeared before the IO and they are
So on their
cooperating with the-
appearance,
Yes, on
they
their-
were not arrested.
No, they have been released.
No, Release means not
After
shown
they-
arrested.
Yes,
When,
They
when
would have
they,
been shown arrested.
they shown arrested.
Yes.
Where,
This
where
would
is the
have been-
documents?
but I don't have
no,
the-
it's not
the
shown as
document.
arrested, your lordship.
Because the
If your lordship may
In
take the page 14, the two alleged accused persons, namely Hirak Jyoti and Saranjit, appeared before the IO along with an anticipatory bail granted in the Honorable High Court bench. As such, record their statement as follows. And your lordship,
Now
page
close.
15, the two
eligible
the two alleged
persons
accused
were
were
released
released
after
after
recording
recording
of
of
the.
their statement.
No, so it doesn't say that they were arrested also.
Nothing is shown, your lordship.
So on their appearance, if required, could have arrested.
Your lordship,
If required, if IO required, they are.
if, but
arrested.
maybe by taking their statement, since there is no element, your lordship, maybe
Okay.
they are not shown. as
Okay,
well.
so you have any objection if
Your
this?
lordship, as far as the statement is concerned, your lordship, since
Nothing.
they are cooperating, your
Hmm.
lordship may pass necessary order. Your lordship.
Okay. Mr. S. Sophie,
Yes, okay, my lord.
counsel for the applicant. This is, okay, separate, no? I've also heard Ms. S. Mary, learned public prosecutor for the state respondent staff. Huh? By an order dated 26/3/2024. While calling for the record. No, LC, while calling for the CD, case diary. By this order, only case diary was called for?
By 26/3/24.
Okay. Calling for the case diary. Case diary, where it's called for? The accused applicant, sorry, was has been protected by an interim order. While calling for the case diary, it is provided that in the event of the arrest of the accused applicant in connection with Mokokchung Police 2, case number 03/2024, under section 379(34) of the IPC, he shall be enlarged on interim pre-arrest bail on execution of a bail bond of rupees 40,000 with one surety of like amount. With the further condition that he shall avail himself for interrogation by the IO and shall not directly or indirectly induce, threat, or promise, promise to any person acquainted with the fact of acquainted with the case, in the fact of the case. Staff, Thereafter, the accused applicant reported before the eye of the case on This is when
Dated 3/4.
3/4. 3/4/24. In connection with the above PS case stuff. On his appearance, the IO has recorded, IO examined and recorded his statement under 161 CRPC and released him. Stop. Para. Miss Mere Lana PP produced a scanned copy of CD and I have perused the same. So there is no other material also against him?
No.
As per the records. Except for the way where the any witnesses has stated that they are involved. Who has stated? Have you seen? No.
Your Lordship, it is the in the city. I don't have the copy.
Anyone?
The other three accused has
Okay.
disclosed that the two applicant is involved. That is why they have been.
The FIR was closed against other three accused who have already been enlarged on bail, and on the basis of their statement, and sorry, on the basis just. Those three accused persons took the name of the present accused applicant, and on the basis of such statement, the accused applicant apprehended, filed this application apprehending his arrest, filed this pre-arrest bail apprehending his arrest in connection with the above PS case. However, the Lane PP fairly submits that there is nothing against the accused on record. And since the accused applicant is cooperating and is appearing before the IO of the case, appeared before the IO and is cooperating the investigating agency, she has no objection if the interim anticipatory bail granted to the accused is made absolute. Stop. In view of the above, the interim anticipatory bail granted to the accused on 26/3/2024 hereby regularized and made absolute with the same terms and conditions, with the further condition that the accused shall appear before the trial court before the same terms and conditions, with the appearing before the IO and all that will remain, and then the money, all those will remain, with the further condition that the accused shall appear before the trial court regularly. Stop. with the above this bail application stands allowed and disposed of. This bail application shall be read along with the interim anticipatory bail order dated 26/3/2024. Is it okay?
Yes,
Okay.
Lordship.
My lord,
Similar order.
for-
Similar, yes.
Maybe 4 and 5.
Yes, both
For-
11, 12, similar order.
Yes, my lord.
Similar.
Obliged, my lord.
Ibrana, section item,